Good afternoon and good evening, YouTube. Today we're going to be talking about COVID-19, the court systems. I already covered this in one video previously about corruption. This is an updated video on corruption in the Superior Court of Contra Costa County, and this is also going to be regarding the current COVID epidemic and how it is being used to conceal the violation of citizens' rights and obstructing the course of justice and proceedings of justice. And we're going to tell you how to go around that as well. So let's get started. I have a letter here from the Superior Court of California's Barry Baskin, and I would like to show you guys this as it talks about the COVID, and we're gonna go over this as well. So let's show this video, this letter. This letter says, thank you on April 9th for your letter concerning the courts during the COVID-19 pandemic. The court's effort to deal with the public emergency delays my response. Okay, so he has a delayed response. The courts are open for. The court is open for current criminal matters, including arraignments, as to protect the rights of speedy trials. That is false. We'll get into that later. As interpreted under the emergency order in chief of California Supreme Court Honorable Tani G. Cantel Sakayui, in her role as the chairman in the Judicial and Emergency Rule of Court, issued by the Judicial Council in some cases in order to rule the extending trial deadlines. Cannot do that. You have the right to 60 days. It cannot be waived, nor conferred, nor implied. They have to give you a yes or no answer. In some cases, these orders and rules have been extended, have extended trial deadlines and affected particular bail schedules. So that means they're now holding people and affecting the rights to bail under the 8th. And the courts have properly applied these rules in those contexts. Of course, they're going to say something like that. The courtrooms are currently in use. What I found out was they were in use, but they were only in use in limited use, and they were only using one courtroom or two courtrooms, controlled by maybe one or two judges. And it goes on to say, provided that these are not closed. Where was I? I'm sorry, I lost my spot here. Have been extended by particular bail skills adopted. The courtrooms are in use and in public and subject to social media distancing protocols. Okay, so they're protocol distancing people to keep people from the virus from spreading, provided that the matters are not closed to the public by law. So now they're just saying, well, certain matters are going to be closed to the public by law. Certain ones are not open, which means now they're denying people the right to a public trial. I mean, public doesn't just mean family members are there. It means people from the public, people including strangers, can go in there. It also then goes on to say, we have also made remote technology to further expand the access and feasible. The court is not holding closed hearings except permitted by law. So the law allows them to permit closed hearings in violation of the Constitution. Okay, well, they can't do that. Article 5 of the Constitution of the United States states that we have the right to a public hearing. Finally, there is no court-wide policy to depopulate the jails. Questions regarding the testing of inmates, the guards testing for inmates or of guards should be directed to the sheriff's office. Well, they just after talking with Lieutenant Wooden, they tell you to direct your questions to the medical. So they just back and forth with you. Now this letter is regarding. This is, as you can tell, is the Judicial Council of California statewide emergency order by the Honorable Tani G. Cantel Sakai, Chief Justice of California. Now, I want to read this very closely. It states that the World Health Organization, the United States Disease for Control and Control Prevention, and the state of California have recognized the country is facing a threatening of COVID-19 on April 27th. CDC reported that there were almost 100,000 cases and almost 54,000 deaths. California's Department of Public Health has more than 43 confirmed cases and 1,700 deaths. So it says in this country there's over 1 million cases and over 54,000. The California Department has confirmed 43,000 of those and 1,700 deaths. Now here's where it gets tricky, is the second line, because if you read the line very closely, starting at on March 19th, Governor Newsom issued an executive order in 3320 requiring all Californians to stay home and subject to certain limitations. Okay, that's to keep people from seeing what is actually going on, meaning the violation of constitutional rights, civil rights violations. They want us to stay home. Now, if you read the line where it says March 19th, Governor Newsom issued executive order for the Californians to stay home. On the second page of this, you can find this actually online, this order. The second page, on the second paragraph, Governor Newsom on March 27th issued executive order in 3820, which among things suspends the government constitution 68115. That's very, very important to know. That law is suspended. Now, if you go down to the, I believe it's the third page. Here, let me pull the third page. It states that the here on the second paragraph of this page, pursuant to the constitutional and other legal authorities granted by Governor Newsom in the Judicial Council of California, Article 6, Section 6, Government Code 68115, which has been suspended, so he cannot actually use that code. And after careful consideration, balancing the constitutional due process rights of criminal proceedings with the health and safety of public courts, staff, judicial officers implying lawyers and judges and bailiffs. Those are all officers of the courts, witnesses, juries, and others presenting the proceedings among considerations that I find good cause. That 60 days in the criminal jurisdiction, criminal jury trials has been extended 60 days, was to conduct under Penal Code 832, both which I authorized on March 2nd to extend 30 days, which he cannot do. He cannot extend a constitutional right beyond the length of 60 days, because that is a constitutional right. It is the supreme law of the land, Article 6, Section 2. The total extension of 90 days shall be calculated from the last date in which the trial could have been calculated under the Penal Code 832 as illustrated below. Now, this is very, 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 very important to know, because that 1382, this is 1382, Penal Code 1382 to 1385, it says the court, unless good cause, The court's contrary is to show and shall order the action to be dismissed in the following cases. This is section 2 of that section. In felony cases, when a defendant is not brought to trial within 60 days of the defendant's arraignment or rearraignment of the criminal proceedings pursuant to the chapter 6, commencing with section 1367 of part 10 of title 10 of part 2, or in cases that cause it to be tried again following a mistrial. So basically, what they are saying is we are claiming a mistrial, and we are granting a new trial without the use of appeal, and is being appealed through the Superior Court. So now they're appealing the rights after the case has been dismissed, but they're not properly going about saying how they're doing this, and they are now allowing another 60 days for it to be resubmitted, or they also state that there was a 90-day extension, which, let me continue to read. After a mistrial has been declared, or after filing a remitter, that's with the Supreme Court, in the trial court, or I guess it was filed in the trial court, or after the issue of a right, or the right order is filed, the trial court has served upon the prosecuting party, attorney, or within 90 days of the notice to write is ordered and filed with the trial court. So what they're doing is filing a remitter with the trial court, and then using that 90 days to retry the inmate. They're not extending it 90 days. They're claiming a mistrial, filing a remitter, then retrying the inmate, and allowing another 90 days to go on beyond that. And so, let me keep reading here. After 90 days, notice of the right is ordered and is filed in the trial court and served upon the district attorney who chooses to resubmit the case for preliminary examination. So what they are doing is filing a remitter to the Superior Court and extending it 90 days beyond the law using that 1382 section 2. And I'm going to add this to the video, but people need to know that this is going on. So let's continue reading what the Superior Court and the Supreme Court has been doing to violate constitutional rights. So where were we? We were here. The extension in those matters in the trial court to Penal Code 1382, which occurred between March 16, 2020 and June 15th, will result in the range of criminal trial for the month of March that could last through the Penal Code 1382, which would be extended to June 14th, 2020, and the criminal trial for June 15th, 2020, the last trial date could be considered under Penal Code 1382, which would be extended till September 13th. That's the 90 days through the remitter through the Superior Court. Now, Section 3 is very important because, look, there's that government code again, 1685. 68115, subsection A10. Any previous extension of the time under the criminal trial under Penal Code 1382, which in that same section, I think it's section B, states that if you don't say anything, it's implied consent. So you are consenting to the violation of your rights because you either A, do not know, B, you are not being informed, and these are all violations and should be considered a mistrial. Now it's standing up for your rights, but let's get back to this. Any previous issued extended time which the conducted criminal trial under Penal Code 1382 that I authorized under the emergency order issuing an individual court pursuant to Government Code 68115A10 shall run concurrently with the extension authorized in this paragraph. Well, you can't do that because that has been suspended. So they're authorizing under that which has been suspended, such that the local authorized extension of the Section 1382 deadline in any case is 90 days. Well, no, that's for a remitter. Now, that just shows that they continue to violate the law. Because Gavin Newsom is not actually helping us. He's actually playing ball with the people who are running this charade. Now, the courts, Section 5, the courts extend the need for further extension of time in which conducts criminal trials. It shall be submitted under Government Code 68115. Remember, that has been suspended, and describes specifically facts supporting and request, and specifically addressed in efforts to make avoid unnecessary further extensions, including collaborations with the justice partners and use of available technology. Now, this is where it gets really interesting, because at the bottom here, he submits it. This is page 404. The courts, this relief is temporary in intent to address the COVID-19 pandemic and poses a challenge to the court proceedings. I reserve my authority to rescind or modify this order. So he can remove this order or modify it at any point. He did leave it open for himself as appropriate to address any change in circumstances. This order may be deemed part of the record and affect cases for purpose of appeal without any need to file. This order may be deemed part of the record in effect cases for purpose of appeal without the need to file the order in each case. So he has made it so that he doesn't have to file an appeal in every single case, basically giving himself less of a workload. Okay, and he is giving himself absolute power. And as you can see, there's dated April 29, 2020, signed by the Honorable Tani G. Katel Sakai, and this is just a blatant disregard for the constitutional rights of the individuals of this state and many other states. Now, this is a letter from the Superior Court of California, and I'm going to show you this. This is by the presiding judge of Contra Costa County. This is dated May 11th, 2020. I want to show you this again. I only went over this briefly. On April 9th, he received my letter. It's dated May 11th. They are using the rights to speedy trial, but we do not have access to a speedy trial because it's being violated. And so we're being denied rights to bail because they're picking and choosing who's going to have a bail hearing and who's not. I just happened to be lucky and be rolled in with a good attorney, and then was able to be pro per because I pretty much have a pretty good concept of the law. Nobody has a great concept of the law because the law is so vast and they make so many laws. But it also goes on to say that the matters are not closed to the public, and then it double talks you. Now, there's a ways around this to find defects. You can find defects in this case, any case, because no attorney has a bar license. No attorney has a real license. That license is a union card. Show me a real license. Show me your oath of office. It's the same thing with a a cop. A cop arrests you. Well, you want to make FOIA request. Make a FOIA request to the bar. I want the union card. I want their actual, not the union card. I want their actual license. But I also want the union card because that is a union card that is not a license. What they're doing is actually illegal. You have the right to represent yourself if you understand law. They are extending private laws to police to lawyers, and only lawyers who have bar union cards, not actual license. And you can actually get the case dismissed because of the lack of standing. Now, when you go in there, you are actually not going in there and challenging the jurisdiction. You're just stating that you are the beneficiary equitable title holder because everything is equity. Everything is regarding commercial law. And this is what they run by. Now, you go in there considered as a minor under the CFR 33.6.3. You are considered a minor even though you are an adult and have reached the age of majority. And because you have not taken control of your account, this is how they create a bond in your name. And that bond is your estate. And this will be covered in a later video. But this is just some of the stuff that is going on. Now, Contra Costa County is notoriously corrupt. And I have just shown you the actual corruption that is going on with the COVID stuff. And this is a continued action by our state, by our governors, by our Supreme Court, by our superior courts, our appellate courts. They are all in cahoots, and they are all violating the law of the citizens of the United States of America and committing acts of treason. And we, as citizens, need to be informed and need to understand and comprehend what is going on and educate ourselves. We have people in jail that I have personally seen that should not be in jail, but because they don't have a comprehension of the law, and then they further choose not to educate themselves, or their families choose not to educate themselves so they can help their family members. It makes it very hard on that individual who is being constitutionally violated by a criminal act of a judge who does not have a bar license, a state bar license, which is still a union card, a judicial union card, does not have an actual license, by lawyers who have a union bar card who do not have an actual license, by challenging the fact of standing, and then doing FOIAs, which would allow an individual to acquire those informations and say, well, I don't think you have actually any standing. And going in there with the right and proper papers and the proper FOIAs, you can actually have a case dismissed because of the lack of standing. And this is it's a type of leverage that you can have. If they choose not to dismiss your case, well, then you can print in the local paper and say, hey, look, I wish to print. I think it's like $5 in the paper, and you print out all the information that you have acquired through those FOIAs. Make sure it's factual, because you can get a lot of trouble for not putting actual factual information. But then again, now we live in an age where everything is not always what it seems, like I've just shown you. And we need change. It is time for change. time for the people's voice to be heard. I will have another video at a later date and time. Thank you for watching. Thank you for listening. I'm going to put some of the information down at the bottom of the page, including the 1385. I'm gonna put the letter from Judicial Council of California, statewide emergency order by Tani G. Cantel Sakai, Chief Justice of California and Chair of the Judicial Council Board from April 29th. And I'm going to put some more information down there. Please share this video, comment, and educate yourself on your rights, your family's rights, and those who you have who are loved ones, who are your wives, your children, no matter who they are. Educate yourself so you can inform them and tell them what is going on, and their rights are being violated because of the use of this COVID to manipulate the system and extend laws that are illegally being used and misinterpreted by our officials. Thank you for watching, and have a wonderful day, wonderful night, or afternoon, wherever you are, and God bless.